All right. Thank you so much, everybody. My apologies for running a little bit late. Claire Ladd, our Programs and Services Manager, encountered some technical difficulties. So, my name is Megan Murphy, and I'm the Marketing Communications Coordinator for MNN, and I just had to step on real quick. So, apologize for my little disheveled appearance here. Thank you so much for joining us today. Just a few housekeeping items before we dig in. So, the recordings and slides from today's program will be emailed to you following the webinar. So, just please keep an eye on your email address for that. And if you have any questions for the presenters, please submit them via our Q&A function. And if you have any logistical questions or questions about MNN, please feel free to drop those in the chat and I will respond. And I just wanted to give a little background about us here at MNN. So, our three goals at MNN are to strengthen the nonprofit sector through advocacy, public awareness of our sector, and capacity building services. We offer regular webinars in partnership with our affiliate members as part of our capacity building efforts. So, please stay tuned for future topics in the coming weeks and reach out to us if you have any topics you'd like to see. And our efforts are made possible by our more than 600 member organizations. To those of you who are members, thank you so much for your partnership with us. We greatly appreciate that. And if you have not yet joined the network but would like to take advantage of the member benefits, such as networking opportunities, trainings, and cost savings on various professional services, please visit massnonprofitnet.org/join to find out more about that. And today's webinar is titled Navigating the Current DEIA Legal Landscape. And our presenters today are Eleanor Evans and Emily Wagman of Hemenway Barnes. And I will hand it over to our presenters to get started.
Great, thank you. Well, I'm Eleanor Evans, with a partner with Hemenway Barnes in our nonprofit practice group, and our firm provides a variety of legal assistance to a wide range of nonprofit organizations here in Massachusetts and elsewhere, ranging from operating 501c3 charities to private foundations, schools, colleges, universities, religious organizations, and many others. And so we've been getting a lot of questions and have been doing a lot of presentations on this topic since the new administration took office in January, and have been advising our clients of all sorts on how to respond to the current DEI legal landscape. So thank you very much for joining us today, and I'll turn it over to my colleague in our nonprofit practice group, Emily Wagman.
Hi, everyone. My name is Emily Wagman. I'm an associate in the nonprofit practice at Hemenway Barnes, working closely with Eleanor.
Great. Well, so we're going to move on to the presentation now. And we're going to, we have slides that we'll be using, but we also very much welcome your questions and comments along the way. So please do put those in the Q&A, and we will respond to them throughout the webinar. And we're going to be talking about the background and the laws about this, but we'll also be touching on some scenarios. And so feel free to jump in at that point or other times with your questions that you may be encountering in your day-to-day work around DEI initiatives. So first of all, just want to give you a big picture of sort of how to approach this legal environment by looking at what steps we should be taking at this time. So basically, it's doing an organizational assessment. So reviewing your organization's mission, values, and priorities. And it's really important to start with that and to always keep that front and center in your thinking around DEI matters and how to address them. Then you want to identify any race-based programs or initiatives that your organization may operate or fund. And it's really important to note the difference between those that address issues or communities versus those that select or exclude individuals on the basis, or organizations on the basis of individuals' race, color, national origin, ancestry, or ethnicity. So the latter is more problematic. Just addressing issues or serving communities as a whole is not as much of a risk as making specific decisions about funding or other resources based on individuals' race. So you can reduce the race of discrimination claims if you don't use race to exclude individuals from DEI-focused programs or initiatives. So then in having reviewed your organization's mission values and priorities and what any particular programs that you may be operating, then you want to look at your organization's risk tolerance. So some organizations say, look, this is completely central to what we do and we wouldn't exist if we didn't do these things, and we're willing to take these risks and address any consequences at the time that they might arise, then that's totally fine. But you just want to be clear on what degree of risk tolerance if you have. If, say, you receive federal funds and you don't want to risk those funds, then your risk tolerance may be different. But we have seen some situations where a nonprofit did receive federal funds, but that wasn't their entire funding portfolio. And they decided that, that this DEI work that we're doing is so central to our mission that we're going to give up those federal funds to enable us to keep doing what we've been doing. So we've gotten a lot of questions from people about reviewing terminology and should we scrub our website or other public facing social media or other aspects of the organization that face outward. And certainly, if you can review terminology and you can, change wording on your website and elsewhere, but, you do want to maintain your organization's commitment to principles of equity and inclusion if that is key to your mission and values. Also, you want to review your program operations, your grant making, if you make grants, your employment policies and practices, and any restricted gifts your organization might have received to identify areas where you might need to consider changes or steps to minimize your risk in this current environment. And then you'll want to engage with stakeholders, whether these be grantees or your other members of the community that you serve, to discuss and consider, your continued support for DEI work, even if you may not continue to call it that. And then I just urge all of you to join with other organizations such as MNN or national nonprofit organizations to speak out for the rule of law, due process, and the importance of civil society organizations in this environment. So I was talking about risks around DEI. So let's look more deeply at what some of those risks might be. So if your organization receives federal funding, then there is a risk that you could lose it over DEI activities, and perhaps some of you may already have lost funding or been required to change your DEI activities or stop doing them in order to continue to receive federal funding. And many organizations, and perhaps some of you, have had federal funding suspended or terminated due to DEI initiatives that perhaps the prior presidential administration had required as a part of your grant applications. Another risk is undergoing a government investigation or audit. Again, less likely to happen if your organization does not receive federal grants or contracts. And so far, we haven't seen any IRS audits or, that have been publicized, or investigations of 501c3 organizations based on DEI initiatives, but we'll talk a little bit about the 501c3 rules a little later in the presentation. But the investigation could be brought by the IRS or perhaps some other government entity or another executive branch or entity or Congress. And I have seen some clients be contacted by congressional committee. It wasn't around DEI, it was around immigration issues. But, Congress does have oversight and, can convene committee meetings and can investigate matters. And so that is another possibility. Another risk is getting sued over what the plaintiffs might call an illegal discriminatory practice. Even if your organization wins, you'll be incurring legal fees and other costs and may face increased publicity. So some organizations are willing and say, we're willing to continue with our DEI activities, and if someone sues us, so be it. Other organizations are more risk sensitive around that. But just know that if you do get sued over a DEI activity, if it's by a private plaintiff, most likely they're going to be seeking for you to end or alter your program in question, as opposed to pay money damages. We're going to be talking about some lawsuits around DEI issues, and in most of those cases, the resolution has been that the organization changed or terminated the program in question, and not they didn't have to pay money out. One theoretical risk could be losing your 501(c)(3) status or other tax-exempt status. I think that's somewhat unlikely at this point, unless you're a school, and we'll talk a little bit about that there have been some rumors around, or I should say news stories, or that the administration may be considering some actions regarding private nonprofit schools and racial discrimination. But for other nonprofits, it's less likely. Those are kind of overviews of initial steps to take and some of the risks. So now we're going to do a deep but quick dive into the different laws that apply. So Emily, I'll turn it over to you for this part of the presentation.
Thanks, Eleanor. So all organizations, regardless of whether they receive federal funding, are subject to Section 1981 of the Civil Rights Act of 1866, which we'll talk about on the next slide. Title VII of the Civil Rights Act of 1964, and to the extent that you are a Massachusetts-based organization, Massachusetts Fair Employment Practices Act, as well as the Massachusetts Public Accommodations Law, and then Internal Revenue Code Section 501(c)(3), which governs tax-exempt status for charitable nonprofits.
Sorry to interrupt. It does look like we have a couple of questions. The first one is sort of circling back. So do organizations need to cease using the words diversity, equity, and inclusion in their policies and practices?
And so the answer to that is it depends. If you do not receive federal funds, then there's less risk that that those sort of trigger words could cause some sort of legal risk to you. However, it depends what your organization does and what your policies and practices are. There's nothing illegal about promoting diversity, equity, and inclusion. And in fact, there's been some guidance issued by the Massachusetts Attorney General, who takes a different view of these issues than the Trump administration, indicating that, taking steps to promote diversity, equity, and inclusion in employment is a good thing, and that there are ways to do that without making decisions to hire or not hire someone or promote someone on the basis of their race. That's always been, well, at least since the 60s or so, always been illegal to, make employment decisions to promote or not promote or hire or not hire somebody, or other employment decisions based on somebody's race. So you can't do that, but you can certainly take initiative to expand the pool of applicants that you might receive to make sure that you're recruiting people from all different races and considering them in your applicant pool. So it does kind of depend on your on what it is your organization is doing. If you receive federal funds, then you may want to remove that terminology from your website and public-facing documents. Then there was another question that is, and so we'll take questions throughout, but I may hold on some until a particular time in the presentation. But I do see that there is another question here of what if we run an internship for a certain population? We receive funding from one organization to then host a person from a specific community, in this case, a Native American tribal community. So is this is a condition of the funder? Should we consider opening up the pool to non-tribal members, or is that protected? So this raises two issues. So one is about the issue of, whether you can exclude people based on or include people based on their race. So, if you have an internship program for for people from a particular race or ethnic group, then that can be problematic under employment law and potentially under Section 1981 of the Civil Rights Act, which we'll talk about. So it is best to open up your internship opportunities and other similar type of programs to people of all races. But you could have other criteria such as, you know, obviously, I guess internships would often be like early career, people earlier in their career, or you could have it be for people who have certain experience in certain areas, or maybe, like you could say for people who have experience working in with Native American communities, if that is something that is, where or that would be of a benefit to the types of programs and activities your organization runs. And then we'll also be talking about restricted funds later in the presentation, where funders or private donors might have given you or may want to give you in the future funds that are restricted to be used for particular people. So scholarship funds for BIPOC students, or, funds for internship for, for a particular population based on race, then you may need to go back to the funder and say and explain to them the current, in the current environment, that this is problematic, and so therefore ask for the restriction to be lifted or for the terms to be broadened. And if you can't, if the funder or donor is no longer alive or available, then you might have to go to the Mass Attorney General or to court to get the terms changed. And we'll talk about that later. So I'll hand it back over to Emily.
So Section 1981 of the Civil Rights Act of 1866 prohibits intentional racial discrimination in making and enforcement of both public and private contracts, and protects people of all races. Non-race-based criteria are not within the scope of Section 1981. So this really does just cover any race-based discrimination in contracting. In a Section 1981 suit, for the plaintiff to prevail, they must show that the alleged intentional racial discrimination was a but-for cause of the plaintiff's injury. So someone who did not receive a contract would have to show that the racial discrimination was the cause of not receiving that contract. So Section 1981 applies to contracts, but not gifts. And whether an arrangement is a gift or a contract depends on state law. Contracts usually require offer, acceptance, and either consideration or reliance. And it really doesn't take much to form a contract. They don't even need to be in writing. But Section 1981 will cover that, which is why we have seen organizations moving away from grant agreements to what's called trust-based philanthropy, which can be useful in addressing Section 1981 concerns because there is no contract in place. If your organization does not receive federal funds, you could consider structuring race-conscious grants, scholarships, and programs as gifts with no, or as few as practically possible, strings attached to not be within the purview of Section 1981. So if you are making a grant to a particular recipient, you could note that the grant or scholarship is a charitable gift and not a contract. This is not dispositive. If it meets the requirements of contract law, it will still be considered a contract, but it does sort of put a thumb on the scale in the right direction. You could also note that the recipient will not provide any services or anything else of value to your organization, and that reporting from the recipient, while welcome, is not required as a condition of receiving the funds. Additionally, if you're an organization that runs BIPOC leadership training programs, you could make participation in those programs free of charge, which would lean you more out of the realm of contracting and more into the realm of gifting.
And so I'll just jump in here to talk about to just note that I mean, we've gotten a lot of questions around, oh, well, how can we make our granting or our programs not contracts? And there's no magic language. I mean, you can have a document at the top that says gift, but just because you said that doesn't mean it's a gift necessarily and not a contract, and vice versa. But what really matters is whether you have so in law school, they teach us that to make contracts, you have to have an offer. Somebody makes an offer of something to do something or to pay somebody something. The other side accepts, and then there's consideration. So meaning that there's an exchange of value going back and forth between the two parties, or that one party relied on the statements of the other party to provide a value to the other party. And um, so it's somewhat of a fact-based analysis as to whether a particular arrangement is a contract or is a gift, but the fewer strings attached that you can have associated with it and the fewer requirements for the people receiving the services or benefit, the better. I also, so I also see we got a question in the chat. So if people could put their comments or questions for us in the Q&A, just so we don't have to look at the chat and the Q&A, that would be great. But from the chat, there's a question of somebody who works for a grant maker that does not receive federal funds. They grant out to many organizations and institutions that do receive federal funds, and including scholarships. And so some of the scholarships have fund instruments or fund documents, which are, contracts essentially, and that may have selection and criteria that include race. Does that impact the institutions that accept the scholarship on behalf of the student? Um, yes. So if the scholarships are going to schools that receive, I mean, so if your organization is making a grant and it's going to a school or a college or a university that receives federal funds, as most do, then they have their own requirements under federal funds that make them unable to discriminate on the basis of race. And we're going to be talking about those. And so also, even for those institutions, they're not supposed to have information on their website that directs students to scholarships that are restricted on the basis of race or in some cases gender. So anyway, there can be risk there. And so I see that the question also says many of the donors may have passed away. And so therefore the person asking the organization that's the grant maker can't go back to the donors and get their permission to change these or remove these restrictions. And so, as I mentioned before, if that's the case, then you will either need to go to the Massachusetts Attorney General's office if it's an old fund, 20 years or more old and worth less than 75,000 dollars, or if it doesn't meet those criteria, then you'll have to go to court to request that the restriction be modified or removed. And we'll talk about that later in the presentation. And I also do want to note here, based on another comment that we received, that that the current situation is creating a lot of fear among nonprofits, and not just around DEI, but all the other things that are coming at us these days. And I don't want to, create fear here. This is just based on helping. This presentation is to help people determine, as I mentioned before, their risk tolerance, just to know that there are these issues out there, not to necessarily feel that because you've heard about, some of these DEI, the administration's position on DEI, that you must jump to conclusions and you must change your programs or you must scrub your websites, because that is not necessarily needed in all cases. And it's up to each organization to determine how it wants to respond to this current environment, and based on its mission and values, how it wants to, structure its actions going forward. So we're just giving you tools to think about that, and resources, and to just give you the lay of the land from a legal perspective. Great. Sorry, Emily, for that diversion. Please go ahead.
So we'll quickly touch on a recent Section 1981 contracting case that addressed a grant contest run by an organization called Fearless Fund, which was a Black woman-owned venture capital fund and its affiliated 501c3 Fearless Foundation. The contest involved grants of $20,000 that were to be distributed by the foundation, and eligibility was limited to businesses that were majority owned by Black women. The American Alliance for Equal Rights brought a Section 1981 contracting suit alleging that the grant program created a contractual relationship between the foundation and grant applicants, and that restriction of eligibility to businesses owned by Black women violated Section 1981. The Council on Foundations and Independent Sector did file a friend of the court brief seeking dismissal on First Amendment grounds, arguing that that foundations and individuals have a constitutional right to donate to charitable causes that align with their values, which could include efforts to support historically marginalized groups. In June of 2024, however, the Federal Appeals Court granted a preliminary injunction that prevented Fearless Fund from administering the contest, holding that the contest was in fact a contract and likely to violate Section 1981. It also concluded that the contest was an act of prohibited discrimination rather than expressive speech protected under the First Amendment. It's important to note that this decision only covers Georgia, Florida, and Alabama, but it is indicative of where federal courts are likely to go with regard to these types of lawsuits. The parties ultimately settled, and Fearless Fund agreed to discontinue the grant program. So as Eleanor noted previously, many of these privately brought lawsuits are less about monetary damages and more about getting the organizations to stop the programs that they're running.
Also, federal courts in other parts of the country may hold differently. And I should note that in that case, it was at a very preliminary stage. So it was a preliminary injunction. So they hadn't had a whole trial and fleshed out all the facts and that sort of thing. So if a case were to go further along, it's possible that it could come out differently, depending on various circumstances. However, it seems like if something like this did go to the Supreme Court, I might expect the Supreme Court to come out where the appeals court in Fearless Fund did.
There was a similar suit in August of 2024 where an organization called Founders First Community Development Corporation settled a suit that challenged its grant program, which limited eligibility to Texas-based businesses owned by individuals who were Black, Latinx, Asian, women, LGBTQIA+, military veterans, or located in low to moderate income areas. Similar to the Fearless Fund case, the federal court granted a preliminary injunction, finding that the grant program violated Section 1981 by applying racially discriminatory eligibility criteria. Founders First did not dispute that the program involved a contract, and when settling the case, they agreed to not consider race in awarding the grants or to collect data about applicants' race until after selecting and announcing the grant winners. We can quickly touch on this one. There's a similar suit against the American Association of University Women in August of 2024, where fellowships are restricted to women of color and open only to women from ethnic minority groups. Overall, we have seen an uptick in legal challenges to corporate grants aimed at Black and Hispanic-owned businesses, as well as employers' DEI hiring and training programs and race-based scholarships funded by private organizations, all alleging that they violate Section 1981, and in the case of hiring and training programs, that they constitute reverse discrimination, compelled speech, or that they cultivate a hostile work environment. And again, these these are suits that are brought by private individuals against, organizations that don't necessarily receive federal funding. Title VII of the Civil Rights Act of 1964 says that it's unlawful for an employer to discriminate on the basis of race, color, national origin, sex, or religion. It covers employers that have 15 or more employees. But it's also important to note that state anti-discrimination laws also apply based on what state the organization is in. In Massachusetts, the state public accommodation law prohibits making any distinction, discrimination, or restriction in admission to or treatment in a place of public accommodation based on race, color, religious creed, national origin, sex, gender identity, sexual orientation, deafness, blindness, or any physical or mental disability or ancestry. So this is a little broader at the state level than it is under Title VII. And Mass law further defines places of public accommodation as any place, whether licensed or unlicensed, that are open to and accepts or solicits the patronage of the general public. So it can include any of the types of organizations listed on the slide and can be very wide-ranging.
And so it is broader also than federal public accommodation law, which tends to focus on more like the first few things like theaters, restaurants, hotels, things like that. But note that the Massachusetts law also covers things like childcare centers, senior citizen centers, homeless shelters, and the like.
We're going to quickly touch on Internal Revenue Code Section 501c3. So to qualify as a tax-exempt organization under Section 501c3, a nonprofit has to be organized and operated exclusively for religious, charitable, scientific, testing for public safety, literary or educational purpose, or to foster national or international amateur sports competition, or for the prevention of cruelty to children or animals. Additionally, no part of the nonprofit's net earnings may inure to the benefit of any private shareholder or individual, and no substantial part of its activities may be carrying on propaganda or otherwise attempting to influence legislation. And for private foundations, there's a prohibition on any lobbying at all. Additionally, to qualify under Section 501c3, an organization can't participate or intervene in any political campaign on behalf of or in opposition to any candidate for political office. The illegality doctrine is another concept that impacts charities, and it prohibits them from engaging in illegal activities or actions that violate fundamental public policy, even if the action isn't necessarily illegal. An organization with an illegal purpose cannot qualify for federal tax exemption, and even if the organization has a legal purpose, it won't qualify for tax exemption if it engages in substantial illegal activity. And this came up in the Bob Jones University Supreme Court decision back in the 80s. The IRS had revoked 501c3 status of private religious schools with racially discriminatory admissions policies, including prohibiting interracial dating and marriage on the basis of their religious beliefs. The Supreme Court upheld the IRS's position, holding that an institution seeking tax-exempt status must serve a public purpose and not be contrary to established public policy, which in this case was, anti-discrimination legislation in cases like Brown versus Board of Education. The court, further went on to cite authority from all three branches of the federal government as evidencing a fundamental public policy against racial discrimination in education. We saw this come up recently with a post from President Trump on Truth Social in response to Harvard's pushback on a letter of demands from the Trump administration that made the news earlier this year. President Trump threatened Harvard's tax-exempt status, saying that tax-exempt status is contingent on acting in the public interest. So this indicates that the administration has considered using the Bob Jones University rationale to revoke the tax-exempt status of nonprofit organizations behaving in a way the president doesn't like. There have also been some tax law developments recently. Back in April of this year, the American Alliance for Equal Rights requested that the IRS open investigations into the LeGrant Foundation, the Gates Foundation, and the Create Capital Foundation, all three of which have scholarship or grant programs open to individuals of color. Less than 2 weeks later, the Gates Foundation agreed to open its scholarship program to white students. Last month, there were some news reports that the Treasury Department is considering an IRS revenue procedure that would prohibit private nonprofit schools from retaining their 501(c)(3) status if they discriminate on the basis of race in areas like financial aid, use of facilities, or other programs. Under current guidance, policies that favor racial minority groups in admissions, facilities, and financial assistance is not considered impermissible racial discrimination if the purpose is to promote the school's racially non-discriminatory policy. Additionally, there is executive branch authority to limit or revoke 501(c)(3) status. The president does not have the authority to direct the IRS to revoke a specific nonprofit's tax-exempt status. And the IRS also does not have the authority to revoke a nonprofit's 501(c)(3) status without following a required process that does include the right to a court appeal. And the IRS further does not have the authority to revoke a nonprofit's 501(c)(3) status for engaging in lawful activities, even if those activities promote diversity, equity, and inclusion.
So I'll jump in and talk about organizations that receive federal grants and loans. So all the laws that Emily talked about previously apply, and then in addition, the following laws apply. Title VI of the Civil Rights Act of 1964, Title IX of the Education Amendments of 1972, the recent Trump DEI executive order, and the Federal False Claims Act. So Title VI says that nobody in the U.S. shall, on the ground of race, color, or national origin, be excluded from participation in or denied benefits of or subject to discrimination under any federally funded program or activity. And federal courts have held that discrimination that violates the 14th Amendment's Equal Protection Clause committed by an organization that accepts federal funds also constitutes a violation of Title VI. And the reason this is important is the Students for Fair Admissions case that we'll talk about in a moment. It interpreted the 14th Amendment application as it applied to University of North Carolina, which is a public institution, and then it applied the standards that it developed there to Title VI as well in connection with Harvard. So just a little bit more on how Title VI works. So if an organization either receives federal funding that extends to the organization as a whole, or is principally engaged in education, healthcare, housing, social services, or parks and recreation, then Title VI applies to the entire organization. But if the organization only receives federal funds for a specific program and is not principally engaged in education, healthcare, housing, social services, or parks and recreation, then Title VI only applies to that one specific program receiving the federal funds. So as I mentioned, Students for Fair Admissions, it was decided in 2023 by the Supreme Court, and it concluded that race-conscious college admissions policies of Harvard and University of North Carolina violated both the 14th Amendment's Equal Protection Clause in the case of UNC, and for both of them, Title VI of the Civil Rights Act of 1964. And in that case, the Supreme Court rejected the argument that there are educational benefits of diversity and that attempts to remedy the effects of societal discrimination are sufficient reasons to justify discriminating on the basis of race in college admissions. So what they said in Students for Fair Admissions is that you can't use race as a plus factor in admissions. In other words, one among many factors in an individualized review of each applicant. But the court did say that colleges and universities can consider an applicant's discussion of how race has affected them, whether through discrimination, inspiration, or otherwise. Students for Fair Admissions is limited to higher education admissions, but it does have implications in other contexts, especially around things that might be closely aligned with admissions. In other words, might be zero-sum benefits, because the decision referred to the fact that college admissions are zero-sum, and that if one person's admitted, somebody else isn't admitted. So it does have implications around scholarships, restricted gifts and grants, and some race-conscious nonprofit programming. And so after Students for Fair Admissions was when we started to see that uptick in Section 1981 cases, even though challenging, race-based scholarships and the like, even though Section 1981 was not an issue in Students for Fair Admissions. So then there's Title IX, which applies to education programs receiving federal financial assistance, which prohibits discrimination on the basis of sex in federal programs. I should note that it applies to doesn't apply just to schools and colleges. It applies to any education or training program that's operated by an organization receiving federal financial assistance. And it's modeled on Title VI of the Civil Rights Act. So federally funded organizations that provide education or training that are subject to Title IX and can't discriminate on the basis of sex in those programs. I just do want to note that Section 1981 that deals with contracting, as Emily said, only applies to race in contracting. Then we have the DEI executive order, and I just want to note here that executive orders cannot make new law. They can only direct federal agencies how to interpret, implement, and enforce existing law. So the executive orders don't have any direct application to private entities that do not receive federal funds. Although the DEI executive order, as it indicates, it prohibits DEIA initiatives in the federal government and requires some things around federally funded organizations, but it did direct federal agencies to enforce longstanding civil rights laws and combat illegal private sector DEIA preferences, mandates, policies, et cetera. And it did direct the Attorney General to report to the President on a proposed strategic enforcement plan that would apply to private sector organizations. However, we have not seen that plan rolled out yet. With respect to organizations that don't receive federal funds. So when you hear about the DEI executive order, just be aware that if you're a private sector organization that does not receive federal funds, it does not have any direct application to you. The order itself does not define what the Trump administration deems to be discriminatory or illegal, which is problematic. And then on the next slide, the order does require federal agencies to include in all contracts and grant awards terms that require federal contractors or grantees to certify that they don't operate any programs promoting DEI that violate any applicable federal anti-discrimination laws. The issue there is we think we know what that means, but the Trump administration may have a different interpretation of what considers a violation of those laws. And then federal contractors and grantees, once they get contracts or grant awards with this award term in it, have to agree that their compliance with all applicable federal anti-discrimination laws is material to the federal government's payment decisions for purposes of the Federal False Claims Act, which permits suits by private parties as well as the federal government. And so more on the False Claims Act on the next slide. That applies to federal grant recipients and federal contractors and sub-recipients and subcontractors. And it imposes liability on individuals or entities that defraud the federal government by making materially false or fraudulent statements to influence the government to pay. And so normally speaking, this act, the idea behind the act is that, you might hear about how like fraud in Medicare, for example. And the idea is that it's supposed to, if somebody makes a false statement and says, charges for some kind of medical procedure that wasn't performed, then that would be a materially false or fraudulent statement. And I think we can all understand that. But here, there with the grant term or contract term that I mentioned from the previous slide, by signing that, you would be saying that we agree that if we violate federal anti-discrimination laws, that is in itself a material statement. And so if we said that we're not violating, but we do violate, then somebody could bring a False Claims Act suit against us. And the problem with False Claims Act suits is that there's a provision that allows individuals to file suits on behalf of the government and potentially receive a portion of any recovered damages, which could be quite significant. Um, and then, of course, the Department of Justice can also bring suits under the False Claims Act. And the DOJ recently established a so-called Civil Rights Fraud Initiative that will use the False Claims Act to investigate and pursue claims against recipients of federal funds that knowingly violate federal civil rights laws. So if you are a recipient of federal funds, it's important to be aware of the False Claims Act and these legal developments. So turning now to how should we handle various scenarios, and I know that we have some scenarios on the next slide that we'll go through, but feel free to chime in here with any scenarios or situations that you have questions about or are concerned about. So, okay, if an organization has a mission statement incorporating DEI principles, is that a problem? Do you need to change that? I mean, my take is no, you don't. I mean, that's part of your organization's mission. And as long as you're not saying that you're doing something illegal, which you're most likely not, then you obviously can maintain your own mission statement. And putting out a mission statement, also, I should note, is protected by the First Amendment because it's a statement that you're proclaiming to the world of this is our mission. So that is not a problem. Funding nonprofits or acting as a nonprofit to work to end racism is also there's no problem there. Ending racism impacts everybody, and there's no singling out people on the basis of their race to receive society benefits by ending racism. Funding nonprofit BIPOC employees' professional development, that is more problematic if you don't make that program available to everybody, regardless of their race, and the possible laws that people could, bring a claim would be under, Title VII of under federal law and state anti-discrimination law in employment. So the important thing there is if you're funding professional development to make it available to everybody. And we have on here an affinity group for BIPOC employees. Again, you can have affinity groups, but you just need to make them, you could have one that focuses on issues that affect BIPOC employees, but you need to open the group up to everybody and make it clear that everybody is, regardless of their race, is able to participate. Funding training for community leaders on how to increase equity within their organizations and communities, not problematic. That the community leaders could be anybody, regardless of their race, and increasing equity within organizations or communities, benefits the organizations as a whole and the communities as a whole. A grant for a loan program for BIPOC-owned small businesses in a low-income neighborhood. This is along the lines of Fearless Fund, where if you're limiting the recipients on the basis of race, it may not be illegal, but if it is framed as a contract, then somebody could challenge it as violating Section 1981. So that's where it is. So if it's a loan program, you're most likely going to have a contract because you have the loan itself and the requirements around the loan would be a contract. So that would risk a Section 1981 suit. Organizations may decide they want to go ahead and do it anyway. If that's federally funded, you most likely could not do that under Title VI. DEI training for employees, not discriminatory. I know that the Trump administration has on the EEOC website has some FAQ where they say that DEI training could be discriminatory depending and could create a hostile work environment. The Massachusetts Attorney General has, contrary guidance. So it might sort of depend a little bit how you run the program and how it's framed, but it does not necessarily automatically create a illegal discriminatory practice. Funding nonprofits serving women and girls. Again, if you are not a federally funded education or training program subject to Title IX, you can limit funding to women and girls for particular programs. Same with scholarship for women in STEM. This does get into that thing that we discussed earlier with a grant maker. So if a grant maker makes a grant to a university for a scholarship for women in STEM, the university may say we can't accept this because of Title IX. Grants to community prevention programs to empower BIPOC and LGBTQ youth to make informed, healthy decisions about their sexual health. I would argue that this is not discriminatory. Under the Trump administration's view, they probably would, if it were talking about federal funding for this, they would probably say this doesn't align with their priorities and cut the federal funding or suspend it. But if you're using private funds, I do not see a problem there. Grant application scoring for grants to nonprofit that favors BIPOC leadership. So favors nonprofits that are led by leaders who are BIPOC or their board is made up of BIPOC people. Like that, depending on if the grant is a contract, that could raise Section 1981 concerns. And if federal funds are involved, that could be problematic. And then collecting demographic data on race and ethnicity on program or scholarship applicants and selected participants and recipients. Again, as Emily mentioned with the Founders First case, that case indicated that it was better to and would be safer to collect this data. I mean, you could collect it, but not have the people reviewing the applications look at it until after the decisions have been made, so that you're not making decisions on the base, or that there can be no question that you're not making the whatever. Will be clear that you're not making decisions on the basis of race or ethnicity, but you could, track that data to see, who is our program benefiting. Okay, so then somebody did ask a question in the Q&A of, can we clarify again, contract versus gift? So a gift is basically a donation that somebody makes to somebody else where there's like nothing expected in return for that gift. And so where the person is not required to do any particular thing, they just are given the gift. So if I give Emily $100 and I say, here, and let's say Emily and I are friends and we don't work together, and I give Emily $100 and say, have at it and spend this however you want. And that's a gift. But if I give Emily $100 and I say, you need to use this for a certain purpose, or I say, you must, in order to receive and keep this funding, you must, provide these reports or perform this service, then that is not a gift. It's more in the nature of a contract. Okay, I know we're at time, but I know we also got started a little bit late. So we're going to stay on and talk about handling restricted gifts. But if anyone needs to leave, feel free. But I'll turn it over to Emily to talk about handling restricted gifts.
Thanks. So for existing restricted gifts, organizations should consider inventorying those gifts and identifying the ones that reference race, color, national origin, ancestry, or ethnicity. This would involve a review of the gift instruments for the exact language used in the instrument and deciding whether modification is needed.
Also, I'll just pause here. So there was another question that said, so is a restricted gift a contract in the terms of the law? And the answer would be yes, because I'm giving a gift to nonprofit X and I'm saying, it must be used to provide this training program, then the nonprofit X has to provide that training program in order to receive the gift, then that there is an exchange of value there. So it is likely to be considered a contract.
So state law does impact the use of charitable funds. In Massachusetts, restricted funds must be used for their intended restricted purposes, and whether and how restrictions may be modified depends on a variety of factors, including the terms of the gift, whether the donor is alive, or in the case of foundation grants, extant, and the size and age of the restricted fund. If the gift language is deemed to be flexible enough, organizations may be able to administer those funds without regard to race, without external approval. In cases like this, that should be documented internally via a board vote or an internal memo. Otherwise, if the donor is alive, the organization should obtain their consent. And if donor consent cannot be obtained, modification by the court or the attorney general for those smaller, older funds that Eleanor mentioned earlier is required. Looking forward to new gifts, organizations should consider developing and implementing policies around accepting race-based gifts, and convey their values and priorities to donors. You may need to explain to donors the policies on accepting race-based gifts and the rationale for those policies, and stress the importance of flexibility and use of funds. And there may be additional ways to further donor intent without selecting or excluding individuals based on race. So for example, if you know that the donor is interested in STEM, have them consider, granting a scholarship to any individual interested in STEM and not just one in a particular race or national origin group.
Or if the donor is interested in, promoting equity in education, then you might explore with them, funding a scholarship for first generation students, for example.
And then finally, organizations should consider including variance language in their gift instruments, stating that the organization reserves the right to vary from the provisions of the instrument to the extent that in the charity's reasonable determination, the terms of any gift to the fund become impossible, impracticable, or wasteful to fulfill. Doing so is necessary to comply with legal or ethical requirements, or failure to do so will significantly undermine the charitable purposes of the fund or the mission or reputation of the charity. So including variance language in a gift instrument does give an organization a little bit more flexibility to make changes to the language of the instrument without needing to go back to get donor approval. But to the extent that the donor is still alive, it is probably just, good practice to work with the donor to let them know that you are going to utilize the variance language in the gift instrument.
Great. So that ends our formal presentation, and I know we're a little over, but if anyone has any further questions at this point, feel free to put them in the Q&A, and we'd be happy to answer them now. And if you think about this webinar and have questions that arise later, then feel free to reach out to us at our contact information on the slides. And as MNN mentioned, they'll be distributing a copy of the recording and of the slides to you, so you will have access to these after the webinar. So thank you for attending today, and last chance for questions if anyone has them. But not hearing any at the moment, we hope to come across you at an upcoming MNN event. And thanks to MNN for sponsoring this and for being a voice for the Massachusetts nonprofit community. Thank you.
Thank you all, and sorry about the lateness. Um, I can't turn my video on, but I'm here and I really appreciate the speakers. So thank you again to you and to everyone who attended. And yes, we will be sending out the recording and slides, so just keep an eye out for that. And thank you to Megan for doing the introduction. Have a great rest of your day, everyone.
Great. Thank you.
Thank
Thank
you all
you.
so much.